Okay, ready to start. Sorry for the slight delay, and thank you for joining us. Just a slight technical issue to start with, but all sorted now. Thanks very much for joining us today for this third Virtual Innovation Center workshop. Today, focusing on confidence in employee as company grows. So very briefly, the rationale for organizing this workshop is because obviously when R&D-based company is growing, the most important thing is preserving assets relating to intellectual property or know-how. And as we all know, we evolve in a very fluid and agile industry where employees obviously could work from one company to another. And so this whole question about how much you need to involve them and how you need to safeguard and preserve this very hardly developed intellectual assets. So today I'm delighted to be joined by Carissa Upton from Pennington's Manchis Cooper, and she will give us some hints into the legal aspects of that. So what to put in terms of confidentiality clauses with employees, and of course some examples also on how to make the most of this relationship at start, during your employment, and at termination, because this also happens. So very happy to make it interactive. If you have any questions specific to your situation or more general, she's happy to take them. So just drop them in the chat box. And as you probably heard when we started the meeting, this is recorded. And so it is intended to be shared with any colleagues or others that you would like to share with. So without further ado, Carissa, the floor is yours.
Lovely, thank you. Yes, good afternoon, everyone, and welcome to this session on confidentiality in employment. I am Carissa Upton, and I'm a senior associate in the employment team at Pennington's Manchis Cooper in Cambridge. I regularly advise companies in the life sciences sector on employment matters generally, but today we'll be discussing the important issue of protecting confidential information in the employment context. I'm going to do my best with the technology, but this is the first time I've actually had to do all the screen sharing and run the webinar at the same time. So do forgive me if I miss questions coming up in the chat. Feel free to interrupt me, or if anything else goes wrong, I'll do my best. Anyway, so
I'll be here as a backup, Carissa, don't worry.
Excellent. So turning to the agenda then for today's session, we're going to cover the following aspects. Firstly, we're going to look at how confidential information is one of the key assets in any business, examine the various types of information, and then look at what laws there are in place to protect it. I'm then going to consider what action you can take to protect that confidential information at each stage of the employment relationship and after it ends. And then we'll finish off with some more practical suggestions on protecting the confidential information, including some top tips for employment contracts, induction training, that kind of thing. So the key assets of any company include its IP, its know-how, trade secrets, commercially sensitive information, and of course, its people and expertise. So how best to protect each of those assets will depend on the type of asset it is. As I'm not an intellectual property specialist, I'm not going to be spending time today looking in detail at IP rights, but thankfully my colleague Rachel Bradley, who's a partner in IP at Pennington's in Cambridge, is also on this call. So if you do have any burning IP issues or questions, she's assured me she will happily step in and deal with those. So please, yes, do feel free to put those in the chat box, and she can address those for you. But as an employment specialist, I'm going to be focusing on confidential information and how to protect it in the context of employment, which you'll appreciate involves an interplay between all of the assets listed in that slide in any event. So kicking off then, what is confidential information? Well, here are some different types of information that will be used by any employer. Not all of these are going to be classed as confidential information, and as such, not all can be protected. When it comes to protecting information, the starting point is the so-called law of confidence. This law applies to information that's properly classed as confidential, which is basically any information about a business, its products, methods, or know-how that is kept secret. It's often the most valuable part of an organization's business and can be the basis of registrable rights, such as design rights or patents. So the businesses do need to be able to protect it. In the UK, trade secrets, which are those ingredients or formulae that are never protected by patents, have always been considered confidential information, as keeping them a secret is critical to the success of any organization or its product. So in order to be able to bring a breach of confidence claim in respect of information, you need to establish three things. Firstly, the information must have that necessary quality of confidence. Secondly, it must be subject to an obligation of confidence. And finally, there must have been an unauthorized use of the information to the detriment of the rights holder. I'm now going to briefly go through each of those parts of the test. So what does the first test mean? When does the information have that necessary quality of confidence? Well, for starters, the information itself must be proprietary in nature. It must be a piece of know-how or a trade secret. The information cannot already be in the public domain, and it must not form part of the employee's general skill or knowledge. Now, as you'll appreciate, there's always a blurred line between confidential information and acquired skills and knowledge, but it is important to make the distinction because the latter is not going to possess that important quality of confidence underpinning a breach of confidence claim. So informing this rule is that you can't stop employees knowing what they've learned about your processes and know-how. And indeed, you're going to benefit from this as it's going to help them carry out their role more effectively while they're employed by you. However, I think the flip side of this is you must also accept they're going to be able to take those skills and knowledge with them to a new role. And while you can restrict what information they can share with the new employer, you cannot escape the fact that their accumulated information and knowledge is going to enable them to be more effective in their new role in the way that it was when they were performing a role for you. So the second test is that the information must be subject to an obligation of confidence. And that obligation might be imposed by contract, implied by the circumstances of the disclosure, or implied because of the special relationship between the parties. Ideally, confidential information should only be disclosed to the recipient employee under a confidential disclosure agreement or a CDA, or some other kind of contract containing sufficiently robust confidentiality obligations, such as an employment contract. However, it is still possible to bring a claim for breach of confidence, even if there's no CDA or other contract in place, where the information is disclosed in circumstances that clearly impart a duty of confidence, either because of the context of the disclosure, such as the information being clearly marked as confidential when it's disclosed, or because of the special nature of the relationship between the discloser and the recipient. So, for example, the employment relationship is already identified as a kind of relationship where there's this special duty of confidence existing between the parties. Once you've established the information is confidential, the rights holder must then go on to show there's been an unauthorized use of that information to his detriment in order to satisfy the final test in a breach of confidence claim. Use outside of the specific purpose for which the disclosure has been made will be unauthorized. So for example, if you have an internal accountant, say, and they're given information about employees' salary for the purposes of enabling them to check pension contributions, if they then go on and use that information and that disclosure to encourage another employee, perhaps to say to raise a complaint about salary levels, that's going to be outside the purpose for which the information was disclosed in the first place, and therefore is going to be unauthorized use. There are a couple of scenarios where you might think the information loses its confidential status and therefore can't be the subject of a breach of confidence claim. Firstly, where it's shared in a large forum, such as in a seminar. However, it's being established that provided the information was disclosed on a confidential basis, that information can still retain its confidential status. So again, the trick being to make sure it's clearly stated as confidential if you want to protect that confidential status. Similarly, information disclosed in litigation doesn't automatically lose its confidential quality. So as soon as it's used for a purpose other than that litigation, it's going to potentially be caught by a breach of confidence claim. In the employment context, whistleblowing legislation may provide an employee or worker with a get-out or defence to a breach of confidence claim if it can show that their disclosure was made within that framework and therefore benefits by the protection afforded by it. So the relevant legislation is the Public Interest Disclosure Act 1998. Under this legislation, any agreement that purports to prevent a worker making a protected disclosure will be rendered void. In order to benefit from the protection of the Act, the disclosure must be a qualifying disclosure. Now, to be a qualifying disclosure, there must first be a disclosure of relevant information. So in this context, disclosure is widely defined. It can be verbal or written, but it must contain information as opposed to mere allegations. Secondly, the disclosure must relate to at least one of 6 categories of wrongdoing, the most common being the commission of criminal offences, health and safety issues, or breach of any legal obligation, and that can include an alleged breach of an employment contract, for example. And finally, the disclosure must be in the public interest. Now, on the face of it, this test could prove a tricky stumbling block in a lot of cases. However, I think in recent years, what is in the public interest has been relatively widely defined. So, for example, there was a case where the wrongdoing, which was the subject of the disclosure, affected just one employee. But the judge still concluded that notwithstanding this, the concerns were raised in the wider public interest. So it benefited from the protection afforded by the Act. Even if you can establish the disclosure was a qualifying disclosure, it's only going to benefit from that protection if the disclosure was made to one of a limited range of people. Now, essentially, this list includes the employer and certain prescribed regulators. If the disclosure was made to someone other than that person or organisation on the list, further tests are going to need to be satisfied in order to bring the disclosure within the scope of the protection as set out in the slide. Generally speaking, it comes down to whether the wider disclosure was reasonable in all the circumstances. But obviously the bullets there provide a useful steer to the factors taken into account when deliberating this question. Okay, now I'd like to take you through the employment relationship and things to think about at each stage of that relationship when it comes to confidentiality. So starting with recruitment then, on recruitment, you will need to be alert to where the employee has come from. So what obligations might they already have, for example? You need to ask lots of questions at an early stage to flush out any issues there may be in respect of existing obligations that you need to watch out for. You can ask to see copies of restrictive covenants if you become aware that there are restrictive covenants in place that are a hangover from their previous employment or engagement. And you should be clear with the employee that you expect them to honour their obligations to previous employers or clients if they were engaged by previously as a contractor, for example. Then you really need to be clear what their confidentiality obligations are to you going forward. So I think begin by having a clear job description in place and a robust employment contract containing carefully drafted confidential information, IP, and other restrictive clauses. We'll look a little bit more at drafting those clauses shortly. Make sure you provide comprehensive training on confidential information as part of the induction process so that there can be no dispute that the employee was made aware of the importance you attach to protecting confidential information right from the outset. So then looking more closely at things to focus on when drafting confidentiality clauses, here you'll see a typical confidentiality clause in an employment contract. In essence, it provides that the employee may use or disclose confidential information in the course of their duties, but is not permitted to do so at any other time, including after termination, and must also use reasonable endeavours to prevent disclosure by others. As discussed, there are circumstances where the duty of confidence will not apply, and it's generally considered good practice to include these as part of the clause for completeness. As you'll see from the slide, these circumstances are where the use or disclosure of the information was authorised by the board or required by law, where the information was already in the public domain other than through the employee's unauthorised disclosure, and where the disclosure amounted to a protected disclosure under the whistleblowing legislation I was talking about. Something that's really important is that you must ensure the definition of confidential information is clear and detailed, and you must really focus also on tailoring the clause to your particular business. This is crucial, and often businesses do not give it their proper attention. So the general rule is the more specific and tailored the clause is, i.e. the less generic, the more likely it is to be enforceable in the event you have to seek to rely on it at a later date. And I can't really overstress the importance of getting that wording correct at the outset of the relationship, because your ability to make changes to those types of clauses at the end of the relationship is much less. You really need to get your ducks in a row at the start when it comes to drafting clauses of that nature. Moving on to the active part of the employment relationship then, when the employee is actually working for you and how you protect your confidential information and IP during that time. So the starting point is going to be reliance on the law of confidence we discussed at the start of the session, combined with the statutory obligations the employee is subject to, such as potentially under the Data Protection Act, and also any relevant contractual obligations, as we said, usually appearing in their employment contract, but it's possible there could be a CDA. However, simply being able to rely on the legal framework in place isn't sufficient, and it's not particularly practical. Other things are going to be needed to maintain the confidentiality and put you in the strongest possible position to deal with any potential breaches after people leave your employment. So this all really starts with good comms and good training. Make it clear to new recruits what your rules are. So for example, about taking documents home, emailing them to personal devices, disposing of documents. And this obviously is particularly relevant given the increase in home working due to the pandemic. So make sure you have clear systems in place and people understand the rules. Also, make sure you have a clear system in place for reporting possible confidentiality breaches, and encourage, promote that culture of openness so that people feel able to disclose if they have breached confidentiality. 99% of the time it'll be an inadvertent breach, but it's important that they feel able to make you aware of that. I think if you can foster this culture and make your expectations clear, you're going to be much less likely to have problems during and after employment around confidentiality. If there are deliberate breaches, then deal with these using an appropriate disciplinary procedure. Most breaches of confidentiality are going to amount to at least misconduct, with the most severe possibly amounting to gross misconduct and justifying dismissal. However, I think the key thing about this is to show employees that you're taking breaches of confidentiality seriously. And this will obviously then inform their view as to how you might react were they to misbehave after their employment has come to an end. Looking at the situation on termination of employment then, once again, we have the common law and contract law as our starting point. This is where the clear drafting in relation to the definition of confidential information does become key. Employees should be reminded of their obligations when they leave, and it should be ensured that they have returned all confidential information and documents on or before their termination date. Typically, you'd achieve this through writing to them on termination of their employment, confirming all the arrangements around their departure. And as part of that letter, you should remind them of their obligations regarding confidentiality or return of property, and also any post-termination restrictions which are going to continue to apply. You may wish to ask the employee to give a declaration that all confidential information has been returned and or deleted from personal devices as part of their exit process. So once you've done all that, what else can you do to protect the business? One thing that is worth giving full consideration to is how you are going to treat their notice period. In this respect, it can be helpful to put an employee on garden leave for some or all of their notice period to keep them out of the market while they're still employed by you, and therefore still subject to a greater degree of control by you than they will be once their employment has ended. During that time, also information may become out of date and therefore less of an issue if it is subsequently disclosed in breach of their obligations. Also, most senior employees are going to have a range of restrictive covenants such as non-compete clauses, non-solicitation clauses, non-dealing clauses and the like, which kick in post-termination of their employment. Now, these can be used in conjunction with confidential information clauses to provide another layer of protection. If you are entering into a settlement agreement on termination, this can also be a useful opportunity to tighten up any confidential information clauses or introduce new ones. Similarly, you may be able to negotiate the employee signing up to post-termination restrictions at that point. But as I said before, if you don't already have these in place, it can be very tricky to get them to agree to this on termination. And even if they are willing to agree, the chances are it's going to cost you something to get them to take on fresh obligations as they are leaving your business. I think something to bear in mind is how you terminate their employment and whether it's lawful. And the reason for this is because if you breach their employment contract, you may be prevented from relying on any ongoing obligations, such as confidentiality, which would otherwise continue to apply post-termination. I think a classic example, and where you may have come across this previously, is you are looking to terminate the employment of a senior executive, and they have a long notice period, and you've decided that actually you want to terminate with immediate effect by making a payment in lieu of notice. If you don't have a contractual payment in lieu of notice clause in the employment contract, then by terminating in that way, you're going to be acting in breach of their contract. Now, if you were to do that and you were to breach their contract, it then flips around and the employee is free to say, well, actually, you've breached my employment contract, therefore I'm no longer bound by the contractual obligations in that agreement either. So I'm free to go off and do what I want. So do bear that in mind. I mean, hopefully, if you've taken enough care over your employment contracts, you'll always ensure you'll have a pile-on clause in your contract. So that would avoid that scenario. But there are other scenarios, you know, if the employee is treated in such a way that they believe they might have a claim for constructive unfair dismissal and they resign saying they're relying on your breach to claim constructive unfair dismissal. That's another scenario where you may find employees are trying to establish you've breached the employment contract so that they're released, if you like, from these ongoing obligations and free to go off and do activities and take part in activities that otherwise would be in breach of their obligations. So just be on the lookout for that. So then, what do you do if it all goes wrong? Say you suspect a former employee may have taken and be using confidential information for a competitor. Well, the number one tip is really to act quickly to protect your confidential information, and that will give you the best chance of succeeding in any legal action that's going to be needed. If the information is confidential information and has been used outside of employment, then there's likely to be a breach. But have you suffered any losses? Because if not, there's little point in pursuing a breach of contract claim, because the success of any breach of contract claim is dependent on establishing loss as a result of the breach. Often a theft of confidential information will be coupled with a breach of one or more restrictive covenants as well, such as a non-compete or a non-poaching. Now, if that's the case, you may wish to take action not just against the offending former employee, but also against the organisation the employee has disclosed the confidential information to, as they could be liable for a separate claim of inducing breach of contract. Now, these types of claims can be much more powerful as you're involving the new employer, which has a number of strategic advantages. Firstly, they may be dissuaded from continuing the breach and possibly even from engaging or dealing with the employee any further because they're put off by the hassle of defending the threatened proceedings. Also, commercially, it may be prudent to involve a new employer, particularly if you're seeking significant damages, as they are likely to have much deeper pockets than the employee, and you therefore stand a better chance of actually recovering some of your losses if you were to succeed. I think reputationally too, it doesn't look good for any business to be on the wrong side of a legal claim, and they're going to be conscious of the need to avoid bad publicity. So that is something that's worth considering. The first step after you've decided to act is usually to seek undertakings from the employee and possibly the new employer that they return and or delete any confidential information still in their possession and promise not to breach the restrictions again. That may be enough to achieve what you need. A solicitor's letter, as I say, is sometimes all you need to get them back on track and complying with the obligations. If not, you're going to be looking at your legal claims. Now, as previously mentioned, you may be entitled to damages if you can show loss and that damages is an adequate remedy. But if you can't, you're going to be looking at an injunction to restrain the use of the confidential information further. Where the confidential information is being misused to gain an unfair commercial advantage, and the employee has gained a head start through that, you may be able to secure what's known as a springboard injunction, which essentially stops them in their tracks and seeks to remove any benefit of a head start they may have obtained through that misuse. Okay, to finish off then, before we move on to perhaps some questions, I thought it would be useful just to summarise the practical steps you can take to protect your business's valuable confidential information and put you in the best possible position to maintain that protection after the employment has ended. Hopefully this is going to be a handy takeaway to end on. So starting at the recruitment stage, check whether the individual is subject to any ongoing obligations as a result of their previous employment or engagement. You obviously want to avoid falling foul of these, as you could end up on the wrong end of legal proceedings. Ensure confidentiality is a focus of the induction process. Make sure your employees are aware of which information is confidential and what information belongs to you as the employer as opposed to them. It's particularly important to ensure you have tightly drafted contractual obligations in place protecting your confidential information, and consider the situation after termination as part of that by way of post-termination restrictions. And on that, consider which employees need access to what data and ensure this is reflected in the contracts, as this may need to be relied upon to show that the employee used information for an unauthorized purpose if you're looking to establish a breach of confidence claim. So during the employment, carry out regular training as appropriate and make sure you have effective policies and processes in place, which you stick to, of course, for disclosing any breaches of confidentiality. In the event of any significant breach, I think whether deliberate or not, consider taking disciplinary action to demonstrate how seriously you take matters of confidentiality. On termination, remind employees of any continuing obligations they remain subject to going forward. And then post-termination, if you become aware of a former employee potentially misusing confidential information in breach of their obligations, really act quickly to stop it and limit any damage to the company going forward. So I appreciate that was something of a canter through the topic, but I did really want to give you some practical tips and focus on the practical reality when it comes to dealing with confidential information and how you might best protect it. I'll have a quick look in the chat to see if I've got any questions.
Can't see any burning questions.
To say it now.
But of course, feel free to. Can I kick off with a quick one? That was really good, as you said, coverage of everything from recruitment to termination when that has to happen. I wonder if we're talking about companies who are growing and retaining their employees, they will have them growing in different position or whether. So how often would you recommend to maybe revisit this confidentiality clause if that has to happen, or if that's something that is really set in stone from the beginning?
I think it's really important from the start to identify what you consider to be confidential information, and that shouldn't really vary too much. The point about making sure that the purpose for which the employee is going to have use of the information is identified is pretty, that is really a belts and braces contract. It's not rare you see people setting out the purpose for a disclosure of confidential information in massive detail in a contract, because I think most people recognize that people's roles are going to shift slightly. But if you identify the confidential information in the first place quite clearly and in a detailed way in the contract, then hopefully, that should capture the kinds of information you're looking to protect. And as people move through the organization, because they might have access to different kinds of that information, if it's caught by the general definition, you should be okay. As I say, it really comes down to taking that time at the outset, making sure your contracts are tightly drafted, and particularly when it comes to the definition of what amounts to confidential information.
Yeah, and maybe it goes down to what you said about training as well.
Absolutely,
make sure that they understand everything.
Impress upon employees, the importance of it to the business. And if it is taking a large chunk of their employment contract, that's going to reiterate how important it is to the business, because it's incredibly valuable.
And maybe it's a bit beyond your your contribution here, but I like this idea of training. Is there any good practice on that? Is that something that should be held by the senior execs team, or is it more by sort of peer scientists if they're scientists?
I think quite often it's comes down to who deals with risk and compliance, actually. And obviously, if there is an HR function, whoever's dealing with the HR function, they can be involved as well, because it is, you are delivering training to employees. But I mean, what we're really talking about is the security of the confidential information. And, every company has to have, for example, a data protection officer who might be responsible for reporting breaches of data protection breaches to the ICO. So those kind of people quite often will take on responsibility for training people in maintaining confidentiality and keeping information secure.
Thanks, Gareth.
Did anyone have any IP questions? I appreciate there's quite a lot of overlap between the employment and the IP side here. And certainly as an employment lawyer, I regularly call on Rachel and her team to cast their eye over the IP clauses in an employment contract, because I recognize I am not the expert on that. So I don't know if anyone had any particular IP questions for Rachel.
No, not particularly IP. I had an interesting thought about non-compete.
Oh, yes.
I think, as you mentioned, people are employed for their experiences and their expertise. You cannot sanitize somebody's brain on what they've learned. And some might be more tangible knowledge than others. So again, that sort of links to IP. But if an individual in a laboratory comes up with a better method of doing something, which may stay as a trade secret in the organization, they still have that knowledge of how to perform that trade secret in a way, which technically, I guess, belongs to the original company's confidential information as part of their contract of employment, but they are now elsewhere and know how to do something. How do you balance that?
Would you like to take that one, Rachel, or do you want me to?
Yeah, I mean, it's probably partly employment issue. Sorry, hi everyone, nice to meet you all. Yes, it's probably partly an employment issue in terms of, what truly is kind of the skills and knowledge that is developed by an employee in the kind of former employer, in their former employment, and then how that, the distinction between that and then specific know-how and methods that they develop whilst during that employment. And, that then would be, confidential information, know-how or trade secrets that are owned by the previous employer. So I think it's a grey area. And I suppose potentially it's going to be very difficult for the former employer to know whether or not that employee who's gone on elsewhere is using their, to kind of flip it around, is using their confidential information and trade secrets, if really all they're doing is just taking the knowledge of how to develop a method and then kind of reusing that. I think it's a grey area, and I think it's difficult to know. So I don't know if there's really a kind of absolute answer to that. I think if there's any use of kind of, you know, in relation to that know-how, they needed to use kind of inventions that were owned by the company, or it's any way improvement to kind of previous processes that they've come up with. I mean, then surely that will be the know-how and confidential information of the previous employer. But if it's kind of general laboratory techniques, which kind of people develop through working in the lab, then, you know, it's arguable that that is just general skills and knowledge. But Clarissa, I don't know if you've got anything else to add to that.
No, I think that's it. I think the reality is you're going to look at it in practice, aren't you? And something's going to trigger you as the former employer to think something's going on here. They're misusing that confidential information. Now, I'm not a litigator, you know, and I certainly don't do IP litigation, but I imagine there's a degree of having to compare what it is you're saying they have produced through misuse of confidential information, or whether that's a process, a methodology, or indeed a product, with what you have in place at the former employer to establish, well, actually, what is the extent of the similarity between it? Because, as you say, if it's actually a methodology that they have cultivated and they always would go about a problem in the same way, I think it's going to be very hard if they then take that methodology and use that in the new employer. However, if it's a case of, well, in order to get this, you have to do X, Y, and Z, and you go to your new employer and they're saying, we want you to produce this, and you can show that they've gone and done what was X, Y, and Z at the former employer, and they've done it at the new employer, and they've come up with the same product or whatever it might be, clearly you're going to stand a greater chance of showing there has been some misuse of confidential information there, rather than just, you know, the employee utilizing their skill and knowledge that they've acquired throughout their employment with the former employer, or indeed their former career. You know, but it is a really, really tricky area, I think. And, you know, saying that you have to sit back and let them use their skills and knowledge is one thing. You don't, you know, but if we can identify somehow that there has been a disclosure of what is properly classed as confidential information, then that is actionable. You just may have a tougher job in successfully pleading it.
Yeah, and I think just to add to that, and like I said, Clarissa said, we work quite closely together, and we do work quite closely together on drafting restrictive covenants, which are obviously aimed to kick in, well, during employment, or restrictions during employment, but then post-employment. So I think if they're very carefully drafted in terms of, if you're looking at it from the current employer for employees about to leave, to make sure that, you know, provided they are kind of reasonably drafted and not too long, and again, Clarissa can kind of explain more about that, but in some senses, they can be useful as well to try to make sure that, you know, from your current employees, that if they were to move on, that they, you know, effectively they're not going to be able to move on straight away to a competitor, and, you know, really not be able to help use some of the, you know, some techniques that they learned at the former employer. I think it's to kind of address that kind of grey area, because if they're just going to a completely different company where there's completely different therapeutic area or completely different type of product that they're creating, then again, there's less of a risk that they will use confidential information from the former employer. But like I said, I mean, Clarissa, you come in if needs be.
Yeah, I think that's right. I think it's about a holistic approach. You know, you're not just looking at one way in which you can stop them breaching confidentiality. You know, the clauses are part of it, as I said, but similarly, you know, making them aware of, you know, day to day what you consider to be confidential information, so that they're not looking at those clauses in a vacuum. They've had a practical experience of working with you, and, you know, how you utilize other aspects of the contract, like their notice period, like I said, you know, because there are other ways you can keep them out of the market. You don't always have to fall back on them being bound by that confidentiality obligation.
No. And again, I think that's quite an interesting grey area, isn't it? You know, how long can you reasonably restrict somebody from
it's a tricky area.
Earning, to put it basically, earning a living.
Absolutely, absolutely. And luckily in this country, the law has evolved such that we recognise that it's part of the deal. When you sign up to your employment contract, you know, the overall package you're receiving, if it says in your employment contract you're going to be subject to post-termination restrictions for a period post-termination, we don't have to pay for that period like they do in the States, for example. And it's still, a lot of employees still are labouring under a misunderstanding of how these work. And there's the number of times I hear people saying, oh, well, that's not enforceable, is it? Because it keeps me out of the workplace. Well, no, the starting point these days is it will be enforceable if it's reasonably drafted. What is reasonable? Again, it's entirely case specific. So again, when you're drafting those contracts at the start, I spend a long time with clients going through working out, well, what's reasonable for a post-termination restriction when you're looking at the duration of the restriction, the geographical coverage of the restriction, the type of business you're protecting. And it's all about identifying the legitimate business interest you need to protect. And one of those, obviously, is protecting and preserving confidential information.
Yeah.
Thanks, Dave. I think that's interesting point also from the employee's perspective to be aware of that, of all these post-termination restrictions and what you want to put in it or not, because I think, as Dave pointed, it varies a lot from the type of role you're doing, but also the type of, type of experiment or whether you may do, and some of them may be very common, others are a bit more niche. And so if you're in that niche area or niche market, you as an employee don't want too much restriction because you want to be employable. But on the other end, as an employer, you probably want to restrict a bit more because they would go to direct competition. So
well, yeah, exactly. And that's where it's the competitive nature of the marketplace we work in, isn't it? How much are you willing to pay to get someone to come and work for you, and to be bound by these kind of restrictions, because it will be commonplace to have the restrictions in place if you're working in a niche area. But similarly, how much you as a business can afford to pay someone to do that job. Essentially.
And to retain them.
And
again, going back to Dave's point, is probably the key is retaining them. You avoid all these big questions about breach of confidentiality with competitors.
And as we all know, that's not just about money. That's about working environment. That's about, do you feel the business is going somewhere? Are you supported by your management? All of that kind of thing.
Yeah. But I still think it starts with a good basis of employment contract, because that's sort of sealing the trust between all parties. And so I think it's also very important.
Absolutely. And I mean, just thinking about restrictions and post-termination and, senior people or people who are key to your organization. Another good tip, which I didn't pop in there, is at Recruitment, advise them to take legal advice on those restrictions, so that they can't at a later date turn around and say, oh, I didn't have a clue what that meant. Because actually that's going to stand you in really good stead at a later date. I mean, some people think, oh, well, I'll just get them to sign up to it and then I'll rely on it further down the line. Well, that's one approach, but actually you stand a better chance of enforcing it if you can show that person knew exactly what they were signing up to, and they were very happy to take the package on offer in return for that commitment.
Do you see employers paying for this legal advice for the potential future employees? Yeah,
some will. Okay. I mean, most will probably say,
go and seek legal advice.
We would suggest you take legal advice on these because these are serious obligations. And if the employee turns around and says, well, if I'm that important to you, you'll pay for that, then they may well. I wouldn't know many employers who'd offer it.
No, of course not. Unless they really, really want them, but
exactly.
Probably not much into an offer market. Okay, so if there's no further question, last chance. No, maybe we should call it a stop. So thanks very much. I thought it was a really, really good coverage overview. Recording will be available, so if you want to share again, and we'll share it on When You Close website and social media, you are very welcome to. Thanks very much, Rachel.
Very much.
Everyone for attending.
Thanks, Carol.
Bye-bye.
Thanks. Bye.
Bye.